This video is designed to provide an informative discussion of the primary facts and holdings of Azuko Pty Ltd versus Old Digger Pty Ltd. Old Digger instituted proceedings against Azuko, alleging that Azuko had infringed two of Old Digger's patents relating to drilling hammers, which were used for exploratory purposes in the mining industry. Azuko denied infringement and counterclaimed for revocation of one of the patents referred to as the Giel patent. Not only this, but Azuko claimed there had been disqualifying secret use by the inventor, Mr. Giel, prior to the priority date. Initially, the trial judge observed that Mr. Giel had tested a prototype at a mining site. This mining site was owned by Mr. Gaydon, who was both a friend and business associate of Mr. Giel. Mr. Gaydon gave Mr. Giel an unsolicited order for 5 or 6 hammers in the month preceding the priority date. By the priority date, Mr. Giel had manufactured approximately 15 to 20 hammers, some of which were manufactured following the receipt of Mr. Gaydon's order. Mr. Giel conceded that the hammers had been made with the intention of selling them following the priority date. Therefore, Azuko alleged that as they were manufactured before the priority date, this amounted to secret use, which prevented the Giel patent from being patentable. The trial judge found that there had been use and that this did, therefore, amount to the use being classed as secret. On appeal to the full court of the Federal Court, the majority, Justices Giles and Beaumont, with Justice Heery dissenting, held with reference to Section 18(1)(d) of the Patent Act that the Giel patent had not been used before the priority date. The crucial distinction between the judgments of Justice Giles and Justice Heery revolved around the word used, which appeared in Section 18(1)(d) and the definition of same. Justice Giles held Mr. Giel's manufacture of the hammers was not a use of the invention, as he had not obtained a commercial benefit from what was done before the priority date, and therefore had not obtained an extension on the monopoly period through secret use. In his reasons, Justice Giles distinguished between process and product claims, and expressly stated that the manufacturing of goods did not constitute a commercial use. He therefore held that the making of hammers before the priority date did not amount to secret use because it was not used for commercial purposes. Justice Heery dissented on this point and held that for the purposes of Section 18(1)(d), the word use should be synonymous with the word exploit, and stated that the word use had a long history as a succinct label for the various ways in which practical benefit may be attained from an invention. Further, His Honour stated that if someone else had been a patentee of the Giel patent, and it had been granted in March 1990, a month before the priority date in this case, Mr. Giel's manufacture of 15 to 20 hammers would have been an infringement of such patent. Resultantly, Justice Heery considered manufacturing the hammers to be use of the invention. So what are the practical and policy implications of the positions adopted by both Justice Giles and Justice Heery? Should the position of Justice Giles be adopted, the court may be required to draw an artificial distinction based on quantity to distinguish use of Mr. Giel's unacceptably large stockpiling. This can only add further uncertainty and expense for parties litigating in this area by requiring analysis on a case-by-case basis involving extensive economic evidence as to, for example, the size of the relevant mark. However, should the court adopt the position of Justice Heery, what results is a rather harsh consequence that secret use will be considered to be a freestanding ground of invalidity. As with novelty, one instance is sufficient, no matter how close to the priority date it occurs.